If you need more money, you
Yes.
have it now?
Yes.
So you can, once we come to a figure, you think you can get this paid
Yes.
off? Okay,
Thank you.
I like that. How come you didn't say that?
I'm so excited to see you.
You're excited to see me?
Only because I seen you on court TV the other day. I snapped pictures. I'm like, that's the judge. I'm going.
Oh, thank you. I'm excited to see you too. Yes. It's hard being a celebrity, I guess.
Do you want to?
Here.
All right, third time's a charm.
Don't call these guys. No, okay. I don't know about that charm thing. Hold that. All right,
The first one is on the docket, the rest are just what was in the.
Brad. All right, Lawrence, is it Craig Caro, excuse me, versus Patrick Cox?
Good morning, Your Honor. Dan Troika appearing on behalf of the plaintiff, Lawrence Caro. As the court is aware, this is consolidated with a township proceeding as well. Is Mr. Cox present?
Mr. Lillick, can you put your appearance in?
Oh, I didn't hear my case called, Your Honor. Victor Lillick for York Township and York Township case.
Yes, and that would be people of York Township versus Laura Cox, Laura Cox cases ending in 503 and 504, and Township versus Patrick Cox, 505.
Laura
Your Honor,
Cox is on the Zoom.
Yes.
Easter.
Where is she? Because I don't.
Camera's off. You can't see her.
Ma'am, you'll need to turn your camera on.
All right, hold on, please.
Okay. All right. Your name, ma'am?
Patrick's on his way. He went to the Saline courthouse, not realizing it had been changed to Ann Arbor.
Okay, it was already here, but. Okay. All right, so we have to await arrival. All right.
Thank you, Your Honor.
Where to pass these matters. Okay. Good call, Ann. You just, eventually I'll get something done.
Once. Which would you like to go back to?
Is that Mr. Cox?
Cox.
Ah, it's Mr. Cox. You do the same. Take care. Did you tell Mr. Wasbury what I said?
I did.
Did you?
He said he'll sign me every time if he can.
Wonderful. See, everybody wins.
Thank you, Your Honor.
Yes. Okay, so I've lost Lilick. What? It's like herding a squirrel. We'll never find him. Can you see if Mr. Lilick is out somewhere? And I have her and Mrs. Thompson, and okay, yeah. All right, court does call the case of Lawrence Carroll versus Patrick Cox and Laura Cox. Mr. Cox, if you can come up, you can have a seat at that table. That's fine.
And the York Township case, Your Honor?
Yes, and also the York Township. Go ahead.
So good morning, Your Honor. Dan Troika appearing on behalf of the plaintiff, Lawrence Caro, in the civil forfeiture case.
All right.
And Victor Lillick on behalf of York Township and the York Township case, Your Honor.
Your name, sir?
Patrick Cox.
All right. And Laura Cox, if you could just state your name, please, for me.
Laura Cox.
All right. Thank you. All right, Mr. Tricka.
And, Your Honor, I also note that Larry Caro is appearing
Yes.
by Zoom. So Your Honor is very familiar with this case in one form or another. It's been before this court or Judge Freshour over the last 4 years. Basic issue that keeps happening is that Mr. Cox, who resides at the premises, keeps accumulating materials outside the house. We don't know why he does it, but it has been a concern to the township. Township has repeatedly gotten orders, both from Your Honor and from Judge Freshour, to clean up. Mr. Cox has repeatedly not cleaned up. As a result, the township goes in, they clean it up, and then they charge it back to the property. Mr. Carroll has been stuck with about 12,000 in already assessed taxes against the property based on the cleanup. And there's another 13,850 that Judge Freshour authorized this summer, which will be presumably added to the tax rolls in December. We might object to that, but that's just where we are at the moment. We have not had any control over what's happened in the property code enforcement cases. So Mr. Caro, acting in pro per, filed a land contract forfeiture case back, I think, in January. The situation is unusual. The Coxes, in fact, do make their monthly payments. They made their September payment. So, we're not here telling the court that they're not making the regular installments under the land contract forfeiture. What we are here telling the court is that it's their obligation under the land contract to pay what we've been obligated to pay to the township, which is, that's in my motion, is 24,000 and change. That's a cost that is expressly on the Coxes and not on Mr. Caro. And we've asked the court to enter a forfeiture judgment that would require them to pay that amount in order to keep possession and an interest in the property. We have to have some solution here. This is a situation that's just going to keep going on forever as long as nothing happens. So our proposal is the only one we can think of that's consistent with the law and that will force a solution. They're either going to pay what they're supposed to pay and comply, which is part of what we put into our request, or they're not. And if they don't, then we'll be back in here seeking possession with a forfeited land contract. It's not our desire to kick them out. It's not our desire to claim any equity in the property, although to be frank, we haven't seen the interior. We doubt there is equity at this point, but we got to solve this problem. Mr. Caro can't be getting bills of $12,000, $13,000 every 6 months because Mr. Cox is incapable of keeping the property up to the standard of the code. I'm, all open to suggestions. I know Your Honor is a fair judge and also can be creative. I've done everything I can to think about this. I can't think of any other solution other than to get our forfeiture judgment, and either they put up or shut up. I mean, we are at a point where this has gone on for 4 years. We can't have it keep going. Now, I wanted to address a point. I know it came up before I was counsel of record in the matter, and I just heard it in the last matter. In a lot of these cases, there's a question about acceptance of payment after sending your notice. And in cases where it's a notice to quit for a 1 month, month-to-month tenancy, if you accept rent for a period after the termination date in your notice, then you have essentially voided the notice under the Park Forest case. That comes up all the time. When I first got this case, the first thing I did was look for the law on land contract forfeiture, and there's only one case in the state of Michigan, and that case squarely says that when it is land contract forfeiture, not only are you permitted to accept payments after your notice of forfeiture, you are obligated to. You take them, you apply them to the balance, and we've done that. They're credited for what they've paid if they are able to do what they're supposed to do during the redemption period, then they'll get the benefit of their bargain. But the issue is we just can't keep having this problem come up. I'm not optimistic. We were in court not that long ago on August 18th. And while the township will speak to this, I've seen the photos. The junk is accumulating again. It's growing like a fungus. It just happens. I don't see this ever stopping. So we're asking the court to grant our motion. I wanted to add a couple of technical things. We didn't get a response to our motion. We did send in a request for default last week. We didn't actually ask it to be entered. We asked it to go to Your Honor so you would know that we properly made a request for default since they did not get counsel. They did not file a response. They didn't do what you told them to do by last week, I think it was, or no, I think it was August 28th. They were supposed to do that. Two other things, which I'll tell you, as an officer of the court, I want to be straight on everything. In my motion, I requested a 30-day redemption. The rationale is that we're suffering damage on essentially a daily basis, but I will acknowledge, as the statute says, it's going to be 90 or 180. And if it would definitely be 90 if your court follows the statute, because they've only paid about 245 out of the 280 balance. If the court would consider a shorter redemption based on these circumstances, by analogy, that does happen in mortgage foreclosures and the termination of tenancies. But for land contract forfeiture, the statute says 90 or 180. If the court does not believe there's an equitable basis for deviating from that, then it would be 90 days. And one last point, in the order I proposed yesterday, I included provision that we would have a right to inspect in 48 hours notice. I don't know if that's objectionable to the Coxes. The reason I did that is because we received an inquiry from somebody who said they might want to buy out the property, and they said maybe they can solve this issue. Again, I'm not optimistic, but there's no real way we can do that without actually having the ability to see the interior of the building. If the court thinks that's unfair, I understand it, but I do believe we have a right to inspection under the land contract, and I don't know that the Coxes would disagree. I mean, we are looking for a solution, but whatever the solution is, our preference is to get bought out. But if that doesn't happen, we want them out of the property, and if that doesn't happen, it should be because they're abiding by their obligations under the property maintenance code and satisfying the township. We obviously don't control the township. We are essentially asking the court to make them pay us what we've been obligated to pay the township, and to make the township happy on the issue of compliance. I just think that's unassailable. I don't know what else we could ask for. And the alternative for Mr. Carroll is getting basically strung along for the indefinite future to the point he's wiped out financially. It's not what he signed up for. And while, I'm not here to cast aspersions on Mr. Cox, I don't know what motivates him. He just doesn't have a right to do what he's doing and create these problems for us, either for the township or for Mr. Carroll. So we would ask the court enter our order with the caveat, as I've explained, about the redemption period and the inspection right. And of course, Your Honor gets to make the decision, and we abide by whatever Your Honor would rule. Thank you.
Well, let me just ask real quick. The land contract requires that the Coxes pay the taxes on the premises.
It does that, but it also says they have to pay repair costs if they create a problem. So that is explicit in the land contract. I relied on two different provisions for the assessment that was already assessed last December. We relied on provision 2E, which says they have to pay all taxes and assessments. So I think that's ironclad. For the $13,850, which just happened, we relied on 2B, which says that they have to keep the property in good condition. It explicitly says they have to comply with any and all building use and other restrictions, and they can be liable for cost of repair if they don't. So I submit that's sufficient to support an order from the Coxes to pay the $13,850. In my proposed judgment, they would pay it directly to the township within the redemption period rather than us. We're not looking to make a profit here, but we don't want to be assessed again in December. And Your Honor should know that for Mr. Carroll, this was a big problem. Last year, when the township assessed his property, his mortgage company then took that to be the new tax, and they increased his escrow catastrophically. Although it turned out maybe they were right, if this is going to happen every year or even twice every year, but it created a big problem for him. So our request respectfully is that they be ordered to pay the township, and if they comply with the order, if you enter it, then we're not going to have the issue of an assessment come December. And we do reserve our rights on the issue of assessment, but we're not here to argue with the township, and we're doing our best to cooperate. Thank you, Your Honor.
Just one other question. Assessment of the $13,850, is it $13,850?
Yes,
Okay,
yes. And that's coming from the township. Yes.
right. That assessment won't happen until December of 2023. Is that
The
correct?
assessment on the tax rolls, as I understand it, will not happen until December. Mr. Carroll did file a motion with Judge Frushauer, which we withdrew without prejudice, challenging the ability of the township to assess the property as opposed to Mr. Cox personally. We're not obviously arguing that today. If the court did grant the relief we're requesting, then the Coxes would either be paying the township directly and avoiding the assessment, or they would be forfeiting the land contract.
All right. But there, as I see it, just so that I'm clear, maybe Mr. Lillett can answer this. It becomes an assessment at some point,
It does, correct.
but then there's another point and it could be the same, but there's another point at which it hits the tax roll.
Yeah, what I would say is this, and Mr. Lilick knows more than I do about municipal law. I don't think it's currently an assessment. So Mr. Caro doesn't currently have an obligation out of pocket to pay the 13,850. What I would say is the Coxes currently have an obligation because the land contract places upon them directly the cost of repair. Now, if Mr. Caro had gone out there on his own and done the work, which I wish he could have done, but he didn't feel he could do so safely, then we would be able to come to your honor and say that cost should be paid by the Coxes to Mr. Caro. That's not what happened. The township did the work. We do think that it's ripe because assessment is not the only basis for our request. The additional basis is that they're on the hook.
I follow you. But
Yes.
what's clear in terms of the language of the land contract is that for it to be an obligation that the Coxes have to pay. You're right in terms of the repairs. Get that. But it seems to me almost a more straightforward approach, maybe, is to figure out when this is an assessment. Because at some point, I guess, once the court orders it, it is an assessment against the property.
In a meaningful sense, yes.
Well, I think that's when the assessment happens. What then the township does with that assessment then becomes another issue, because then the township's going to say, okay, this has been assessed against your property. Part of our remedy then is that it hits your tax rolls, because that's the way I see it. Mr. Lilick, can you?
So the way that the order is written, of course, is that the obligation is on the township to provide an itemized statement to the defendants regarding the costs that were incurred by the township with cleanup. That was done. It was not paid. And when it's not paid under court order, then it becomes an assessment that is attached to the property. We have not attached it to the property at this point because we're cooperating with Mr. Troika and his client to try to avoid that consequence if we can.
But it would be
December 31st when it would become attached as an assessment, basically.
well, hold on, because that's I don't want to get lost in these words, because I think there's a difference between the assessment, at least in this court's mind, is actually occurs when it's not paid.
Correct. I mean, essentially, Your Honor, yes.
Yeah, I mean, that's when the assessment really happens.
And
On the 31st, that's when it may attach to the property and become part of the taxes.
Right. The township has to make that decision and place it on the rolls at some time in October, I think.
Okay.
So.
And see, that's what I'm getting at, because the way I read the land contract, assessment and the taxes are those are different things in the court's mind. So if, for example, you were in a circumstance where, let's say, somebody supplied snow removal, the snow removal, and by agreement, it maybe could go on tax rolls at some point when it's not paid. I assess it at some point and then take my further remedy to attach it to the property and it becomes part of the tax roll. So just so that we're all clear, I view those as very different things. I think that the assessment of the amount of the 13,850 has occurred unless somebody shows me something different. And I think it becomes part of that land contract at that point.
And Your Honor, that assessment has occurred and it has not been paid.
Correct. So I don't know that I need to get to the issue of whether or not it's attached to the properties and on the road. I don't know that I need to get there, because under the terms of the land contract, the Coxes would be required to pay that assessment. And so, bottom line on that, and I'll hear from Mr. and Mrs. Cox, but where the court is at this point, is that 13,850 has been assessed and is now part of that land contract. That's my current view of this. Mr. Cox, what do you want to say regarding?
I think
You can either speak from there, you're fine, or you can come up to the podium, whatever you're comfortable with.
I would like to just say that I'm some of these things I'm a little bit confused. But I generally have a grasp of it. And I don't mean this in a disparaging way towards Larry, Mr. Carroll, but there it seems like the tenor of all of this is that I'm failing in every way, and woe is Larry. And I don't mean that in a bad way, but this assessment that was made to clean up the property before, Larry approached my wife and I about a resolution. We did not go to him to look for one, and he offered how that might be done, and so we were to pay him an installment of that every month on the 15th. So mid-month, we were to pay him, and he seemed satisfied by that remedy. So we would pay our mortgage payment, which we have always done, and we would then pay this additional amount mid-month so that he could pay that to his mortgage company, and we would pay all the interest on, I'm sorry, yes.
So what was that amount?
$500 a month.
550.
What?
It's 550.
550.
Okay, so, and I'll let you finish,
Sure.
but I became a lawyer, so I didn't have to do math, but if I look at that 550 being paid, here's what I see in the problem in that. That assessment that's been done can't be paid, like it wouldn't be paid in a year with the additional 550. Let me just say
It
one
was
other.
24 months of payments.
Okay. All right. So that about gets you there. The problem with that though is there's this 12,000, which I can see then the 24 months of payments. I get that. But the problem that I see in it is that now I've got this 13,850 that if the 550 kept going, that won't get touched until 2 years down the road. And then it's going to be another 2 years plus before that's paid. And the way this is going, hold on just one quick second. The way this is going is that if this happens again, there's going to be another assessment, and it's just pushing this thing out so that this number becomes bigger.
No, it's not a
Each time.
sustainable thing. There's no question.
Right.
And I'm not suggesting Larry's under any obligation to offer us that same setup in what is this new assessment. But I was just giving the ground for what happened on that first go around. So the fact that Larry had kind of even said it to us that he's being he's losing all this money, and he's gonna fail, he's gonna bottom out. It is still ours at the end of the day, and based on his own design, this would be something that would not hurt him, and it would benefit us. We appreciated his offering it to us like that, because we recognize that he could have called it due. It wasn't his problem, and we've never suggested there was. Now we have this new assessment, and that's something that can be dealt with in an entirely different way, and he could insist that be paid in the event that we weren't able to pay for it. We're gone. I recognize that, but I just wanted to say that first go around and that first cleanup we are taking care of that. And we are doing what it is that Larry has asked us to do. And so, it only
Well,
makes sense.
let me ask you that. Let me ask you this.
Sure.
Have you made the five, I think your wife, Ms. Cox, I'm sorry, Ms. Cox said it was $550 a month. Is that correct, Ms. Cox?
That's correct. Right.
Yes,
Okay. Have you made those payments?
Everyone.
I have never missed a payment. We have
Okay.
never missed a payment. I'm sorry.
Just trying to, you guys have been there. I'm kind of coming in
Right.
and so how many of those 550 payments have you made?
I believe February was the first one. So we would have made 7 of them. We've paid 35. It's either 3,500 or 4,000 at this point.
Gotcha. And that's of the 12,000
Correct.
that we were looking at. Is that right?
Yes.
Correct.
On the first on the
That's
first.
right.
Right. Okay. All right. Counselor, you agree with that? What?
Your Honor, I attached as Exhibit 4 to my motion, the actual agreement. And I think it's important that the court hear what it says. On January 18th of this year, Larry Caro wrote to Laura Cox and said, "Hi, Laura, here's my proposal. This is contingent upon no further citations and certainly no further assessments against the property in 9384 North Platte. I understand Patrick believes the property is cleaned up and he will have the house wrapped by this weekend and the house fully sided by the end of March. If this is not followed, this agreement is null and void and the full taxes assessments will be immediately due." So Larry extended this payment plan on condition that this problem stop. It did not stop. Instead, there was a new accumulation of debris. There was a new assessment of 13,850 based on a new cleanup. The siding has still not been replaced. It was supposed to happen by March. And now, Your Honor, we're only here talking about the 2 existing assessments. We're now in the run up to a third because since the last cleanup in late July, I think July 28th, there's a new problem, which is why the township is here today with photographs and I think video to show that it has started all over again.
I don't mean to interrupt. That's-
Hold on.
Well,
I'll give you an opportunity. Hold on.
But I will say clearly, Mr. Caro's payment plan to the Coxes was conditioned on this problem stopping. If it had stopped, we wouldn't be here. Mr. Caro was fine with that agreement. You know, he was going to get paid and he was going to be made whole on what the township had assessed his property, but it was conditioned on not having further problems. They failed that condition. We're here because they failed that condition. The township is here. They held them in contempt in front of Judge Fushauer after this agreement, and they're here asking Your Honor for contempt again after this agreement, and the siding is still off. You can see in the photographs the township will show you today, they just didn't do what they needed to do. So we, yes, it was a good deal. It was mutually beneficial, but they didn't hold up their end of the bargain. And so we're at a point where we want to and believe we are entitled to force the issue. If the court's going to go with 90 days redemption, they're still going to have 3 months to make this work, and they'll have 3 months to get a buyer, which would allow Mr. Caro to be made whole, and they could get whatever equity they think the property has. So they'll have time. But if Your Honor doesn't give us relief today, then this is just never going to stop. I mean, unfortunately, it's driven by Mr. Cox's behavior, and I don't mean that to be insulting, but it just is. And we're well past the point of believing any promise that it's going to stop. So that's our reasoning. Thank you.
So I'll let you go just a minute. I just want to get my figures right. If the total amount of assessments and or taxes, I have 25,850.
Well, we did give credit for what they have paid. So in our proposed judgment,
Right.
it's 24,018 and then a $20 motion fee.
Okay, so I'm still lost on the numbers. I want to get this straight because I have assessments and the other thing of 25,850. That's the 12,000 plus the 13,850.
Correct, but they paid some on the 12,000 and we gave them credit.
Right. And that's what I'm getting at. Because if I hear Mrs. Cox correctly, they paid 7 months.
That's roughly correct. Yeah.
Okay, so, but if they, pardon?
If it's not exactly, it's close. That's right.
Well, that's what,
Right.
Mrs. Cox, I'm gonna
Yes.
trust your math a little bit on this, okay? You told me that you paid 7 months
Yeah, I
of the
would, I could
550.
give you the exact, I would have to look at my app that has my receipts, but I can do
Okay.
that. Hold on just a moment. I'm sorry.
Okay, that's fine.
And just so your honor is aware, we did acknowledge 6 months when we filed the motion.
Correct.
I actually don't know what happened this month on the $500.
Well, are you have 500 or 550?
Well, 550, the 50 is for interest, so the credit is 500 per payment.
Okay.
And we knew that that would be the case, that over that period of time, you obviously accrued some charges that we knew it wouldn't be an exact science, but
Mrs. Cox, what were you saying?
I have 7 payments that I've paid him. I have receipts for. The next one would be due the day after tomorrow.
Okay, but you have 7 payments of 550.
Yes, sir.
Would you agree that the credit to the 12,000 is only 500 and that the $50 is an interest type of payment?
I believe that's how the agreement was set.
How it works out. So that then gets me 35 credit to this of 3,500, which then brings, I come to a total of 22,350. I got it.
Take a look. My numbers are a little different and it may take me a second to parse it out.
Because here, just so that the parties understand sort of where the court's headed, if those payments have been made, they certainly get credit for that. And I'm trying to just have a firm figure that we're dealing with. And if I have 12,000, I have 13,850, I come to 25,850. There's then the 7 payments, which Mrs. Cox has indicated, which then, if I do my math, I get 22,350.
So, the difference, which is not large, is because when they did the agreement, which we contend is now null and void, they assumed the assessment would be 12,000, but the actual assessment that appeared on the rolls was 13,168.46.
Got it. Okay, so
And that is stated in Mr. Carroll's.
Your Honor.
13 that, hold on, Ms. Cox. I'll let you, I'm just,
Okay.
what appeared on the rolls?
13,168.46.
16486. Okay.
168.46, yes.
16846.
Yes. 168.46.
Got it. 13,164.
168.
Give me the number again. 13,168 and 46 cents. Thank you. All right. Mrs. Cox, you were going to say something?
Yes, sir, Your Honor. I believe, and if I'm wrong, I apologize, but that 13,000 that was on the tax assessment also included the winter taxes, which are already rolled into my mortgage payment. So if I'm not remembering that correctly, or it's not itemized like that, my apologies, but that was a one line item, as tax. It wasn't separated out. I already paid that.
Okay, I get you. Is that right?
Your Honor, I would have to ask Mr. Carroll. May I ask?
Yeah, go ahead.
Larry, do you know what the assessment on your property in December of 2022 was based on the township work as opposed to regular winter taxes?
I am looking it up on the escrow. The winter tax is only like $800. Oh, this is no longer on there.
Okay, let me ask this. Mr. Lilick, is there any way that you can find out what was rolled over on that?
May be able to go get the property ID and go to the assessment record on the township. Might be.
Can you, because I mean, if the taxes, because I have about
The other way is I might be able to call anybody at the township. What do you got? What are you looking? We have the assessment. Oh, I'm not bad. We have assessments on their taxes yet. 13,000 July. Last year. Okay. Last year, I don't have the assessment. Yeah. Okay. Yeah, I don't have that.
because it seems to me that what Mrs. Cox is saying may be correct. If it just was all taxes, then part of that may already be there.
See if I can find out.
Okay, that's fine. That'd be good. Okay, so we'll be on a pause on this a moment. I know. You just keep recording. I jump to one of Mr. Fink's around.
Yes.
All right. I was just going to ask him, Mr. Fink, were you ready on either of yours or?
We are ready on the Jennings matter, Your Honor.
Okay.
Email the consent order to Ms. White Wing just now.
Oh. He does that. I don't know why. I take it they've not seen this. Can you? That to the Jennings need to see it and sign off. That's what they're going to do.
Your Honor, they have not had a chance to read it yet.
Okay, so where was he when I was just saying that?
I think he was.
I said, that's why I was having him hand it to him, because they had not signed off.
You might understand I'm in trouble for agreeing with you.
It worries me when you are, but no, I understood they didn't have a chance to do that, so I just had my bailiff hand the copy that I had. All right, so we're good. The folks, have a seat, look it over. I want to make sure that you understand what it says and everything, okay?
Jennings, let me know if you have any questions.
You know, sit here trying to be efficient, and Mr. Fink just keeps getting in my way.
I have those figures from the township.
You're switching to that. Okay. Mr. Carroll, what do you have as the figure?
And I just, if Mr. Choika's cell phone was the one he talked to me on this morning, Township of York, in the December issued an assessment for $11,310.50. For the cleanup.
Say again?
There were two assessments that they added together. One was for 11,000. And I just texted Mr. Choika a copy of this from the township. $11,310.50 for cleanup, plus $975 to the township for court-ordered fine of $750, so that the fine that the courts ordered the Coxes to pay to the court, the township added it to my assessment. Attorney fees of $131.25 for June and $93.75 for July for the December 2023. The taxes were $858.06, which leaves a balance of all the assessments together, $12,310.
$12,000.
$310.40.
So, all right. So the assessment less the taxes was $12,310.40.
Your Honor, may I ask Mr. Carroll one question?
Sure.
Larry, did they pay $500 toward that assessment in September?
No, they started paying, no, September's payment isn't due for 2 days. So it was February, March, April, May, June, July, and August. So 7 times 500 is 3,500.
That's what I said hours ago.
But the number will be, is it the number 3,000 or 3,500 as we sit here today?
3,500 they have paid.
Okay.
Right.
And they're very diligent on these payment agreements. I got to give you that.
All right, sir, I don't need to hear that right now. Go ahead, Mr. Lilly.
Your Honor, I have a call into the township to verify numbers related to that special assessment. I have found the previous bill that was submitted in 2022, and the calculation that I came up based upon a sheet here that I have, which may or may not be correct, is $11,219.50. I'm trying to get verification from that, from the township. If he's looking at his tax bill, okay, it probably has that information correct.
Right. Okay, so here's what and I guess this is the figure right now that I'll work with, unless we see something different. That what Mrs. Cox has indicated that the actual assessment was not 12,000 as we were saying, but it's $12,310.40 was the actual assessment for the previous thing, and it included everything. And I'm going with plaintiff's numbers, Mr. Carroll's numbers on that. If I take that figure and then I deduct out $3,500, and that's great.
So from the 12,310.40 minus the 3,500 is $8,810.40.
Say again. 8,000.
Just make sure. $8,810.40.
Okay.
And I believe that the number that Larry gave you did include the taxes as well. I think he gave it to you. I could be wrong, but the way that I heard him, I think he said it included that.
No. He put that on at the end, but he had all of the assessments that came out to the 12,310.40. And then he said there was a separate amount for the taxes. Is that correct, Mr. Carroll?
That is correct, Your Honor. In December, my taxes were billed $13,000.
Okay, I don't need to know the taxes. I'm just saying
Yes.
$12,310.40 was the amount that was assessed less the taxes.
Correct. That does not include the tax.
Yeah, okay, thank you. That's all I need to know. No, it's okay. It's okay. So then if I take that 8810.40 and then the 13,850 and
13,850.
yes, ma'am.
$22,660.40.
Got it. 22,660.40.
Yes.
Thank you. All right. So whether we call it an assessment, whether we call it taxes to the property, I have a total amount of $22,660.40.
Yeah, I believe that to be correct. I'll also check the math while the court was doing it.
Okay. So Mr. and Mrs. Cox, you were saying to me, so there's this agreement regarding the first part, which you kept to, but you understand that the problem that I see here is that this needs to be paid. Okay.
I understand that. Right.
How would you look in getting that done?
Well, it would, I mean, if it were a bill in front of me that was due, we could not pay it.
Pardon?
I said, if it was like a current bill in front of me and that we had to pay, we could not pay that. So I don't know exactly what we would do. If, like I said, if that was a bill that I was holding, we'd have to discuss and figure something out. But it would be wounding.
Okay. So that you, and I haven't ruled yet, but I need the two of you to understand that. If I were to grant the relief that Mr. Carroll is requesting, then you would have 90 days by this court's determination. When I look at the figures, you would have a 90-day period to take care of that.
All right.
All right. I think in a certain respect, all right. And I understand the language that's contained in the agreement regarding the 550 payment, but in a certain respect, you made those good faith payments, and I get that. So I might have some leeway as it regards the 8810 and that payment, right? But the 13,850,
I think I see myself.
you agree with me?
I
don't get that much, so I'm happy.
Well, no, I mean, it makes no sense that Larry would be on the hook for that or to arrange, some payment plan for us. So I recognize that.
Okay, so now,
To the side, I have some issue with it itself, and I'm not really sure how I would go about that.
with what?
Mr. Lillich say something about what he was required to give to us was an itemized listing of the charges associated with the assessment. And not on the first one did we ever see anything. And this time I saw a sheet of paper, and I'm not even really sure where I saw it, but it says cleanup, $13,850. So it's the part of this thing from an itemized listing. I didn't know that I was due one.
Okay, okay, all right, Mr. Cox, let me just stop you for a moment.
Sure.
Because you can make that argument if that's what you want to do. And I get the argument that you're attempting to try to make. That only goes to it being an assessment. Ultimately, this can be put out to whatever, because ultimately that's going to go on the rolls. And then I'm not even dealing with whether or not they gave you an itemized list.
Right, okay.
Okay, I get what you're saying, but I don't know that really gets you to really what the solution is.
I don't think it does either. I was just saying it to the side that it's something I need to investigate how that or what controls the parameters of that, because it just seems to be the most arbitrary charge. And I don't know, maybe that's completely legit, but especially for something of that.
Okay, but Mr. Cox, we can, if you want to, we can have a full-blown hearing on that, if that's what you want to do.
No, it's
But,
not.
but hold on a second. I'm not sure that gets you there. Because let's say this, just hypothetically. Okay, we go through a hearing, whether the 13,850 is the correct number. And all of a sudden I maybe find in your favor and say, it really wasn't 13,850. It really should be around 11,000. Do you have the 11,000?
No, you're right.
Okay, so again, I don't know that gets you where you maybe want to be.
No, I don't think it does. I don't think it does either. I probably shouldn't even said it. I was just saying in my own.
Probably not. But
I was just saying in my own head, I'm just curious, like,
okay,
I don't know what I do with that.
okay,
you know?
Mr. Cox, let me just tell you, I try to just be practical as a judge.
Sure.
Okay. So the reality of this is you two want to stay in that home, correct?
We think so. Well, I mean, of course that is, there's been just so much. I mean, we've had some talk about, Larry's offered, or spoke to my wife about this buyer, and I'm not even sure of, what that is. So I mean that generally the answer to your question is yes. I mean,
Mrs. Cox, do you want to stay in the home? Is that what we're doing here? Or do you need, what are you looking to do? Mrs. Oh, you're muted, ma'am.
There, I'm sorry about that, Your Honor.
It's okay.
I think since talking to Larry yesterday, it's just raised up some different options and everything with this proposed buyer with him. So I can't tell you that I'm 100% sure in what my wishes are at this moment, because that changed a lot yesterday.
Okay. All right, let me ask you two this and this one. As we sit here today, now knowing what you know, what would you like to see the court do? I'm not saying that I can do it, but what do you want the court to do?
Ronnie, you want to take that?
I don't even know how to answer that. I want resolution. I want some kind of resolution.
She just wants some peace. That's the truth. Yeah, I think that's what we want. We want, there's some kind of uncertainty that I think affects my wife even more than me, even though it does affect me as well. I think if we just know what it is, then we'll just know what it is. And of course,
I hear you. And let me just say this. I think it's the same thing for Mr. Carroll. All right. So as I view it, I don't know that the parties are in a different spot entirely. You want to be able to say, okay, if we have to pay X amount more per month or whatever we have to pay, at least we know what we're facing.
Exactly.
Okay. Mr. Carroll, it's the same thing. And I dare even say for the township, but for Mr. Carroll, it's the same thing. What he wants, which is why the initial agreement regarding the payment is set out the way that it is because he wants to know that every year or every 6 months or whatever, he's not facing this. he wants that same sort of peace of mind that you guys want. The township is not in the business of doing this. This is not what they're about. So they would like some peace of mind to say, we don't have to go to this property again. We don't have to go through all of these proceedings and get to the point where all of a sudden we've got to do some cleanup on the property. Then we got to go through the whole process of a court hearing and all of these things. They don't want to do that either. So then the question becomes, how do we get there? Because Mr. and Mrs. Cox, and I just as by way of example, and I'm not ordering this at this point, but if I said, okay, you can pay the $8,810.40 pursuant to the payment plan, all right, that you guys had. All right, but you owe. But that the $13,850 has to be paid in 90 days. You can't do it. So what solution do you see to that?
I'm not sure that I heard, did you say that if we kept the original, the first part was paid, and that the 13,000?
You've been paying the what's left of the 12,000 initial one. You've been paying that pursuant to this agreement, although there's a issue as to whether or not that agreement is still in effect. I mean, I get that. But so if I gave you credit for that, at least in saying they made an agreement, they're abiding by it, there's a part of it that they didn't, but in terms of the monetary amount, they're abiding by it. But maybe as the penalty for violating that agreement with regard to an additional assessment, an additional cleanup, an additional problem, this $13,850, you got to pay it in 90 days. You can't do it. Right?
That's what I'm not hearing. You can't do it? Is that what?
Well, that's what you told me.
Right,
If I told you you
that's
had
correct.
to pay the 13, okay. I mean,
It is largely correct, but I was saying.
well, Mr. Cox, you know, sometimes, especially when I'm dealing with married couples, I sometimes have to listen very closely to what's being said. Because you're telling me it's largely correct. Hold on. Mrs. Cox is telling me I'm correct. She's not putting any qualifiers on it. So here's what I'm going to tell you. I've listened to both of you. Both of you are great people. But on this one, I'm going with your wife.
I'm probably going with my wife.
What?
I'm probably going with my wife.
Why do you put qualifiers on it? She's the one, she says, look, I'm not gonna argue about who I believe, but in terms of whether or not it can be paid, if Mrs. Cox is telling me I'm correct that it can't be paid, I'm going with that. Because I think she's right.
Then I probably are right.
I know. You're just talking.
Well, I know, but I'm just saying, you're asking a question, 13,000.
No, I said, I didn't ask a question. I made a statement. The statement I made is you can't pay it. You gave me a qualifier on that. Mrs. Cox didn't qualify. She said, you're right. Can't pay it.
Well, because it seems likely true.
Okay. You and your qualifiers. I'll just say this. Mrs. Cox, God bless you. All right. So you can't do it. So what do you see as a solution to this, folks?
It seems we will likely lose the house. I would assume in the event, I mean, would you agree, Laura? If
Yeah, I think
you're
that,
correctly,
Hold on, Mr. Cox.
yeah,
I will certainly let you go on, but right now I don't want to hear from you. Mrs. Cox, what were you going to say?
I think that in the event that that was the judgment, that I'm very interested, and so is Patrick, in the possibility of looking at this buyer so that we, are able to fulfill Mr. Carroll's needs as well as our own and move on if it came to that, for sure. So
Mr. Troika, other than the 90 days, um, with reference to, I guess, the total figure really of the 22,660, is there any room to try to reach some agreement? I'm not asking for what that may be, but is there room to do that?
So, there's obviously a lot going on. A big part of our deal with the Coxes is external to us. It's with the township. The township has its own prerogatives. I don't begrudge them for exercising those prerogatives, but we can talk all we want amongst ourselves, like Mr. Carroll did back in January, and reach all the deals we want. If this issue with the township continues, nothing's going to work. I would suggest, I understand Your Honor is trying to be fair, which I appreciate. Your Honor always is, and I try to be as fair as I can while also being a zealous advocate. One option is to give us what we're asking for, put this on for a hearing date 90 days from today, and the court can assess at that point whether in fact the property is forfeited. If 90 days from today, the property is all cleaned up, the township is out of the picture, they didn't pay the full $8,000, but they paid the $500 a month and they paid the 13,850. Your Honor would be empowered equitably to not forfeit the property. I approach this from a certain degree of skepticism based on the duration of this case. And I suspect that in 90 days or 30 days or 120 days, the pile of junk is just going to grow and the township's not going to go away. So I would say for me, and I believe Mr. Carroll would agree, and to some degree, even the Coxes agree, the most important thing is forcing closure. That might mean they lose the house. Mr. Carroll is not even sure he wants it because we don't know the interior condition. He might get it. And if it looks in the inside like the yard looks, that's, it's a Pyrrhic victory. There is a buyer out there, potential buyer. And I suspect that if your court gave the 90 days, which I do think we're entitled to, it's going to force a lot of activity. And what I'm proposing is we come back, as close to day 90 as possible. So that way the court can avoid an unstoppable forfeiture. But we can maintain that and come back if we need to in 90 days and say, Your Honor, nothing has changed. We didn't get paid, or the property is still, the siding's not up, the property is still a mess, the township's breathing down our neck. That would defer to Your Honor the ability to make a decision on whether to extend the redemption period or what have you. That's my suggestion, given the complexity of the situation. What I want most from Mr. Carroll is a process that has an endpoint. And if the Coxes can't comply with that at all, and I suspect that's going to be where we are in 90 days, that the yard is full of debris. I don't control the township. I expect they're going to hold off on trying to get another order to clean up because they know that the effect of that is then the problem will just repeat. So I think if Mr. Cox, either through his own efforts or by getting Mrs. Cox involved or somebody involved, can take care of the township problems, chances are in 90 days, even if we have an order that theoretically would give us an expiration of redemption and a right to possession, Yana would have the right to say, nope, I'm, whatever, you're changing it, you're equitably extending it. I wouldn't be in a position to argue that. I mean, I could, but you have all the authority in the world to say no. And I don't think Mr. Carroll would argue it if the problem went away between now and then. I'm coming at this from the point of view that Mr. Cox has been given a lot of opportunities. There's still, before Your Honor this morning, a contempt motion against them because the problem, according to the township, which is visually apparent, is continuing. So that's kind of where we're at. The court's thoughts really are quite consistent with, I think, the Coxes and Mr. Carroll. The one difference is I think Your Honor has a bit of optimism. I really don't, I just don't from the history of this case. I think that unless Mr. Cox gets help and allows somebody to come in and control this situation, which he has not yet done, in 90 days, what you're going to see is a bigger pile of stuff and an angrier Mr. Lillick not that he's ever that angry, but still, a more persistent or insistent Mr. Lillick. And what am I going to say? I can't say the township can't enforce its code. All I can do in the next 90 days is say, please, Mr. Lillick, don't, because it would be counterproductive for both the township and Mr. Caro to come back in and try to clean it up again while we have this clock ticking. So my suggestion is order them to pay the 22 grand and change, which we came up with. Within 90 days, 13,850 would go to the township because we haven't actually paid it out of pocket. The order I prepared says you gotta, remediate the violations. You got to put the siding back on, which I don't think should be arguable. The siding's off, that exposes the property to water damage. There does appear to have been some work in the last couple of weeks or month or so on that. So hopefully that will take care of itself. And then this will give Your Honor the ability before a final expiration or redemption to revisit the issue. So that's my suggestion. And what it serves for my client is we got a clock ticking. And if my worst predictions play out and everything is worse in 90 days, then I think Your Honor would be persuaded to say, tough, you've lost the house. I mean, that's Your Honor's call, but I think that would be as reasonable as anybody could be to the Coxes. And we would also have going on in parallel a potential discussion about a buyout, which, that I think we all like that to happen, but we can't control that either because it involves a third party.
Mr. Lillick, with regard to what needs to be done to the premises, there's the siding issue. Is that
I'm sorry.
the siding issue? Is that fundamentally it? That needs to.
Siding issue and, the fines and costs haven't been paid. There's a new accumulation of junk on the property, Your Honor. There's a picture attached to the motion that I filed that was taken the day before I filed the motion on August 17th. I have pictures since August 17th showing that there is frankly more accumulation on the property. I know that the last hearing, Mr. Fox indicated to this court that we didn't clean up the property properly. That's not true. I have a video that shows the status of that property on the day of the cleanup back in July this year. I have Mr. Toth, who's here, who affirms that in fact it was cleaned up. And then again, Your Honor, we're back here again with more junk on the property. I will tell the court that, this case was first before this court, you, Your Honor.
Oh, I know.
Okay, all right. There was a judgment that was entered back in 2019. It went to contempt. He finally did clean up the property. A second case was the 2022 case in front of Judge Freshour. It didn't clean up, which resulted in the $12,000 plus assessment on the property at the end of 2022. And now 2023, Your Honor, again, we're back before the court with a new violation. And unfortunately, after being ordered to clean up the property and fix the siding, which is atrocious on the property, it looks terrible, Your Honor. The township was again, forced to go onto that property and clean it up. As you are absolutely correct, Your Honor. The township isn't in the business. The township doesn't want to do this. It is a very, very rare case in which the township actually has to do it. And it's happened twice with the Coxes, Your Honor. So I agree with Mr. Troika that this does not seem like it's going to end by some type of compliance by the Coxes. It's with respect to the ordinance violation, Your Honor.
How much fines and costs how much are the fines and costs that haven't been paid?
Well,
Do you have a total?
Haven't been paid at the 13,000.
You're gotcha. Okay. Okay.
$13,850.
I thought there was another figure you were talking about.
And that includes all the costs up to this page, Your Honor. Although we're here on a contempt show cause, Your Honor, I would be requesting additional costs on a finding that they have not done what they're required to do under the ordinance. I believe I'm entitled to. So again, it's unfortunate. Okay. Nobody wants this problem for them, but they're not They're not taking care of it, Your Honor. That property looks awful. It looks trash. You can take a look at the picture that's attached as an exhibit. You can
I see it.
Siding, Your Honor. That was a sided property. Okay, I don't know what happened to the siding. It's just, it's
I do.
suspected that it came down and was, what?
If in all of the orders, the word replace, or I mean, to reattach all of the siding. This issue, we've discussed it numerous times. Tom took all of the siding. I had all the siding in the backyard. It was all laid out. I took it all down because it's only on one section of the house. See, I think that this is where we really change paths, because the tenor of this is it makes it out like I'm just this horrendous thing, and that my house is atrocious. It's one section of the house
Okay.
that's missing the siding, and it's because I took it down. I insulated the wall. I power washed all of it in my backyard. It was laid out in lengths and by cut angles to the gable. Tom took all of it and put it in the dumpster, and he thought that was humorous. So in all of the things that say to rehang the siding, it actually can't be accomplished because it's not there. Now, to re-side it, put up new siding, can be done. I purchased that. That actually should not have been a charge that I had to assume, but I did get it. I have not put it up yet, but Tom took it. He took all of the things in the backyard, including my trailer. I bought a
Okay.
trailer
Oh,
to comply with this. John, please, if you could just give me a moment.
Really?
There's
Really?
a
That's how
problem
that
here.
works? Okay,
What's that?
yeah, no, go ahead. Keep talking.
Your Honor.
No, let him go. Because he wanted me to give him a moment, so I'm gonna give him a moment.
If it'll hurt me, I guess I won't, but Mr. Lillich just spoke at length. I just wanted to say that my attempts to comply have been interrupted numerous times from Tom, and it doesn't mean that I can't have it done, but it's just fair to paint it the proper color, and that's the proper color.
Okay, let me get away from the siding for a moment.
Your Honor, if I just might.
No,
Okay.
just get away from the siding. Where does all this stuff keep coming from? I'm presuming it doesn't have its own legs and just walk into the property and sit there. Where is it coming from?
I go out and I collect it, dumpsters and different places that discard whatever. I sell a lot of it, and I do a lot of metal scrap. So I take it back to the metal yard.
You're a scrapper.
That's right.
Okay. So Mr. Cox, give me an honest answer. You're bringing all of this back. What's your wife tell you?
She doesn't like it at all.
Yeah. So, not here to get into all your business, but if she doesn't like it, why are you doing it?
I think I may have mentioned this the last time in court. It's just true. It's something I obviously need to get away from. But at the start of COVID,
That's not my question.
No,
That's not even an answer to my question.
but I'm
Mr. Cox, Mr. Cox.
I'm trying to answer your question.
No, you're not.
Yes, I
You're
am.
trying to give me an excuse.
Oh, I'm not, Your Honor, at all.
Oh, you don't want to take that attitude with me. I'm going to ask you a direct question. If your wife is saying she doesn't like it, why is it still happening?
Because it's the way that I can best contribute to our financial life. I lost my job at the start of COVID. Respectfully, Your Honor, this is what I was going to say. And I felt carried by my wife, and I felt a certain level of shame associated with that. And I found a way to contribute, even though she still carried the bag. I was in the game, and I needed to be able to be in the game.
Okay, let's assume all of that is correct.
It,
But hold on. Every time these assessments come up, you're going out of the world backwards.
I'm aware of that. It's a failed.
Well, but hold on, Mr. Cox. I mean, in some respects, I may not even be talking the law at this point. You're going out of the world backwards. Meanwhile, this person who, as you put it, is carrying the bag is just trying to hold things together.
So,
And I'm going to tell you what my thought process on it is right now. You're not helping. At all. Your behavior in doing what you're doing to try to correct it is just making things worse. And I think the thing that maybe you're appreciating in all of this, and I can appreciate sort of the ego trying to make sure I'm providing and whatever. Through all of this, she's told you she doesn't like it. But you know what? She hasn't gone anywhere. She keeps doing what she's doing.
she's my wife.
She's probably a whole lot more than that. I don't know Miss Cox, but I've listened to her. And I get she's a whole lot more than that.
I certainly didn't say that in a limited capacity.
Let me just tell you what I'm thinking, Mr. Cox. I realize you are trying to do what you're doing. The only hesitation I'm having from just granting all of the relief that the plaintiff wants, as well as the township may want in this case. Do you know the only thing that's preventing me from just doing that? Because I can just rule right now. What do you think is preventing me?
Probably my wife.
Absolutely your wife. Like I said, I don't know her. I've just been watching her on screen here today, listening to her. And I am trying my best to not do something that creates absolute disaster for her. I've sat here and I've listened to you. I don't think anybody can say I didn't hear everything anybody said. But I don't think you realize how lucky you are, because if she was giving me all the figures, she's telling me everything that needs to be done. If she weren't here, this case would have been over an hour ago. So maybe, Mr. Cox, what you've got to figure out is how to stop disaster for your wife from happening. Any thoughts on that, Mr. Cox?
I have a lot of thoughts on it.
Any you want to share?
No. I don't mean that in any negative way, but just know that, you know, I find it personally.
No, I got you. Mrs. Cox,
Yes, Your Honor.
I know it's a hard question. I kind of asked it before. What do you want me to do?
If you're considering honoring the motion and doing the forfeiture, I would just ask that anything with the township be paused, including contempt or anything else for this 90-day period. Pat does take care of his dad, and he's not going to do any good for himself, his health, or anyone else if he's held in contempt. And we will do our best to comply. He has started working on the siding. We will do our best to either comply or to work with Larry on a prospective buyer.
Let me ask my question in a slightly different way. Ms. Cox, you all right?
Yeah.
Okay. Taking out the what I would do and then how you would respond. So what I'm really asking is, what do you want to see happen today? What would you like me to do? I'm not saying that I'll do it. I'm just saying, what would you like me to do?
Well, I mean, I don't know what to do about the $13,000 judgment. So I would like somehow that not to be over my head, because we've been paying the rest. I don't know that I've gotten, like I said, everything changed with the offer yesterday. I just want peace. I did talk to when Judge Freshour had us the last time. I did speak and say that, you know, Patrick was very vocal with me that he understands that his need to provide sort of spiraled out of control over the past few years, obviously. and that he is aware of that and is taking steps. His physician has made referrals. He's seen one person. He's waiting for a urgent referral over to see another person that can help him kind of work through a lot of that. So he has taken steps to say that he knows he doesn't want this kind of life for his future. And whatever they call that, I don't know. I'm not a professional, but I'm very proud of him for doing that. And I certainly understand why he did that, especially being a nurse, because I think a lot of people's lives became disrupted by the pandemic. People handled that in different ways. Some maybe are still handling it, such as himself. And, you know, I think if you have people that support you and are in your corner, you can get through it if you can admit. And he has admitted that, you know, he did get out of control and needs that help. So I think that, again, putting him in contempt or anything like that is not going to solve the issue. And in fact, may make things matters worse. All I can tell you, Judge Simpson, is that Patrick's a good man who's just kind of found himself lost, but he's a good man.
Ma'am, I don't doubt that one bit. But sometimes, and I guess we don't admit it necessarily about our partners in life, I think he's a good man. I think at his core, certainly he is. But I think there's somebody in his life that makes him a better man. So I get it. And Mr. Cox, you okay?
Yeah.
All right, look. Part of really what's happening here, and I'm just going to kind of be blunt, is you're dealing with some things, Mr. Cox. Mrs. Cox is sticking by you in terms of dealing with it. And, you know you're blessed by that, but I don't think you even understand how blessed you are by that.
I do.
And so the manifestations of what you're dealing with, which are resulting in these behaviors of continually sort of adding to the property. I think I have a much clearer picture of what's happening. That's why it continues the way that it does with you. So, yes.
Like, might I just suggest to the court, okay? I mean, I think the picture's clear what's going on here to a great extent. I would suggest to the court that the court's contempt powers are broad, okay? And under those powers, potentially have control or can make orders that are necessary to try to remedy some of these issues. They don't have to necessarily be to Mrs. Cox, but I just offered that, Your Honor, as a possible suggestion. The court can always appoint a receiver in this upon finding of contempt also. So I just offer that Your Honor has a lot of power.
Oh, I Believe me, I understand that. Mr. Lilick, I appreciate what you're saying, but the bottom line to everything, yeah, we're dealing with a piece of property, we're dealing with cleanup, we're dealing with all of those things, but at the bottom line of everything, I'm also dealing with human beings. And I'm going to tell you what I say, and I'm just going to be sort of cold-hearted and blunt about it. Pandemic comes, Mr. Cox finds himself in a really difficult position. He's struggling, and I'll say psychologically struggling, to try to pull himself through. I listen very closely to what Mrs. Cox is saying, why she's there. And I'm going to put it another way. And I also realize the contempt powers I have, I can use them or not use them. But appreciate what Miss Cox is asking. And I'm just going to put it another way. She is just asking, out of everything. She's potentially about to lose her house. Everything is just going where it's going. And really, in everything that she said, she's only asked me for two things. One is, and I'll just say she's amazing in this regard, because the first thing that she asked me for is just peace. She needs, which I took as at some point for her, she needs to take a breath. But I think the other thing is probably a lot more important that she was asking me for. And what she was asking me for is, and she doesn't want anything contempt on Mr. Cox, because really, as a wife, what she's asking is, don't strip my husband of any dignity that he's already thinks that he's lost. Mr. Lilick, that didn't come from out of some law book. What she asked me was just out of pure love for him. Court's going to stand in brief recess. I'll come back and give you a decision on this.
Your Honor, can I make one comment? I think it may be relevant, and I may be wrong. I thought this original case came before you in 2019, which was brief. I just want to put on the record that if that's true, then the narrative about this being COVID related falls apart. So I say,
no. The original case came there, but I don't know. I'm leaving the bench. So you can keep talking if you like, but I'm leaving the bench. Court stands in recess.
thank you.
All right. 14A District Court of County of Washington, State of Michigan, is now back in session. The Honorable Judge J. Cedric Simpson.
All right, you may be seated. In York versus Cox, as well as Carroll versus Cox.
Here's what the court's going to do.
I saw you take it down.
Thank you. Did. Let me just say at the outset, and I say that this at great risk, but I'm going to say it anyway. Ms. Cox,
Yes, Your Honor.
sometimes people come into courtrooms and sometimes they believe that they're not heard. I want you to understand you were heard today by this judge.
Thank you.
Loud and clear. I wish the ability to grant peace came with this robe. It doesn't. Maybe sometimes through these proceedings, I can facilitate certain things that can get you there. But I think if I had the absolute ability to grant peace, I'd just be signing that order all the time. But I can't do that. Sometimes to gain that, I think, though, you just need to be able to breathe a little bit and we figure it out. Right?
Yes, Your Honor. Yes, sir.
So the court has decided to do today is I'm going to grant a judgment subject to the court's review to Mr. Carroll for forfeiture. The redemption period, the court is even at this point going to extend to 120 days. I will set a review hearing on the matter for November 14th, 2023, 9 a.m. in person. As part of the redemption, the total amount will be the $22,660.40. The $8,810.40 of that will be paid as the parties had agreed at the additional $550 per month. So those payments will continue throughout any period. The other amount will become due. The court is reserving the right to extend the redemption period in accord with the court's equitable powers to do so under the circumstances. With regard to the citing, I am going to order that the citing on the premises is to be up prior to or be the November 14th, 2023 date. You understand that, Mr. Cox? The more, well, it is part of a difficult issue, but I'm going to address it this way. Mr. Cox, you are not to bring any more materials or scrap onto the premises. All right. You understand that, sir?
I do.
Without saying it directly, because again, sometimes everybody's business doesn't need to be thrust into the world. I have a pretty clear or at least somewhat clear understanding of why this is happening and why certain behaviors are occurring. I will offer to the Cox, and I'm not saying that you have to, but I understand that Mr. Cox is making a journey in terms of seeing people and talking with folks. All right. Whatever medical or evaluations regarding that the Coxes would like to provide to the court, you may do so. If you provide it to the court, you can provide that under seal, meaning bring it to the court. If there's something you want me to see and take into consideration, in a sealed envelope, tell them that this is get directly to me. I will make a determination as to whether or not it's shared or would issue a protective order so that it cannot be shared, so that I can take a look at it. I realize there are things, some of which are of a psychological nature, most likely, put it that way, that may be going on. And the more information I have regarding that, probably the better off we are in terms of the court trying to reach a fair and just resolution of it. You understand that, Mr. Cox?
I do.
Mrs. Cox, you, and I know you're a nurse, so you understand what I'm saying.
I do. Thank you, Your Honor.
With regard to any type of contempt, and Mr. Lilick is right, the court's powers are very broad in that respect. And at this juncture, any type of request for contempt or anything along those lines, the court is going to decline to exercise those powers today. Will adjourn that, any type of proceeding regarding contempt, to November 14th, 2023. That hearing. I'm doing that because, and just so the record's clear, I think certainly the court can issue orders of contempt, but sometimes also prior to doing that, the court also has to find mercy in its heart for certain things. The plea of Ms. Cox not to issue a contempt order, and it was interesting that she picked that out of all things, is because she does not wish to have Mr. Cox's dignity completely stricken. And this court wholeheartedly agrees with that. And I'm not going to be a part of that at this juncture of these proceedings. I need to see more before I would venture down that path.
Thank you, Your Honor.
You're welcome, Ms. Cox. Are there any other questions regarding the court's decision?
Your Honor, did you address the cleanup of the property at this point, or
The new things that are coming on?
stuff that I heard you say that no more stuff on, but the current status of the property is that there is a bunch of junk on the property at this point, so it needs to be removed and resolved. Township prefer not to have to go back on the property and do it, but
I don't have a problem ordering that.
But what I also know is that if I order that, that creates a greater struggle. And, you know, folks, I'm just going to lay it out this way, and I'm not saying this to embarrass Mr. and Mrs. Cox at all. We're dealing with certain psychological issues that can only be taken in certain steps. And so part of that's going to be not, I'm trying to take, I'm not a doctor, I'm not a psychologist. I mean, I'm trying to take that in steps. One of the first steps really is going to be, at least in my opinion, and just my best guess, educated guess at it, is to not have any more come on.
Your Honor, with that regard, then would it be appropriate for us to go out there, go onto the property and take good pictures today or tomorrow so that we got a status quo?
That's fine. Take photos so that we know that that's not occurring and that Mr. Cox would be complying with that order. Any other questions regarding the court's order?
Your Honor, is this something that you want one of us to prepare and submit to the court?
Yes, you may do that, sir.
And a couple of questions, want to make sure I have this right. The math, 120 days from today is January 10th. And I'd like to put it in running from today as opposed to when the order is entered. So I'll put a hard date of January 10th.
Correct.
Otherwise, I understand that the 13850 will be used for the end of redemption. Obviously, on November 14th, we'll have a conversation about the current status of things. Mr. Carroll lives in Kentucky, so if it's okay with the honor, I would ask him to appear by Zoom, and I'll be here in person.
That's
And I would like to put into the order, if your honor will bless this, that Mr. Carroll has a right to inspect the interior upon notice. I don't know if the Coxes would agree, but if there's going to be any parallel discussion about a potential sale,
right.
We don't want to just show up and knock down the door. We don't have the right to do that. This could be about, and I think in Ann Arbor, it's like 48 hours, 48, 72, whatever. I'd like to stick in a provision that we can provide notice, come and take a look, document the condition on the inside because it's either good or it's bad, and that's going to make a big difference in how this plays out.
Gotcha. Mr. Cox, you have any issue with the interior inspection?
No.
All right.
Oh,
Mrs. Cox, how much
No.
time in anticipation of an interior inspection would you need?
I'll leave that to Patrick because I've been traveling out of state much of the time for work.
Okay. 72 hours notice.
We'll do that. And it may get my email. Mr. Carroll has I think as your honor may appreciate it, he's able to talk to the Coxes. I don't think this would be conflictual. We just want, whether it's, 3 days or 4 days, whatever, the ability to see, because that makes a big difference in where he comes out this and the ability to sell the property. To be clear, the 550 would be as previously treated, 500 applied against the assessment, 50 would just be interest. And then I didn't quite follow through, but we are not at this point going to include the provision that the current scrap on the property be removed within the redemption period, or would we put that in? We could.
Correct. What I'm indicating is that there's to be no more materials.
No more. All right. And then we do have pictures from yesterday, and I understand the township might go today or tomorrow and document, but we have a pretty good baseline as things stand. And to be clear, Mr. Lillard, you need to go onto the property or through it from the road?
No, I think it would be appropriate to go onto the property and take good pictures of everything. Doing it from the road gives a perspective that, may or may not be accurate.
The township has the right to enter the premises for the taking of those photos.
Okay, and I'll put that in the order, but it will happen before you get the order and enter it. But I don't perceive there's any objection. This is just an outside inspection, right?
Right. Now, if I could just ask that someone get a hold of me because of my dogs.
Okay. Just
They're gonna come.
somebody let him know. All right.
And then we'll have the in-person subject to Mr. Carroll will be by Zoom the 14th at 9 a.m.
Correct.
You want that in the order, or would you, with the court issue?
You can put it in the order.
Okay. Okay.
All right.
I think that, I know I have more questions, but that's all I can think of now.
All right. Mr. Cox, do you have any questions? Mrs. Cox,
No, Your Honor, thank you.
you don't have any questions?
No, sir.
You know, and I'll just leave you with this, Mr. Cox. I think you understand how blessed you are. Mr. Cox,
I do.
you know, out of all of everything that was going on, a lot of heavy issues, kind of just let your wife talk. And what she said in very few words was a whole lot of things. Just mountains of information in just a very few words she was speaking. That's one of the reasons why you're blessed. But the other thing is this. Despite all of the difficulties and everything, she could have, may not have been able to provide it, but she could have asked me for the moon. She didn't do that. She just asked for peace. Okay. She asked that you not be held in contempt for your sake. Right? And then through all of it, the one thing that she wanted me to know, and it didn't fall on deaf ears, is that you're a good man. I may not trust anybody in this courtroom. For whatever reason, I trust her. And if she told me that, I'm going to believe it. And I need you to act in accord with that. Understood?
Very much.
All right. Thank you, folks.
Thank you.
I will send that shortly.
All right. Here, I wrote nothing. Shocking.
I'm ready for this one when you are.